we back at chapter 2 of transfers of property by act of parties. A. Transfer of property, whether movable or immovable. 5. Transfer of property defined. In the following sections, transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself and one or more other living persons, and to transfer property is to perform such act. In this section, living person includes a company or association or body of individuals, whether incorporated or not, but nothing herein contained shall affect any law for the time being in force relating to transfer of property to or by companies, associations, or bodies of individuals. 6. What may be transferred? Property of any kind may be transferred except as otherwise provided by this act or by any other law for the time being in force. 8. The chance of an heir apparent succeeding to an estate. The chance of an heir apparent succeeding to an estate. The chance of a relation obtaining a legacy on the death of a kinsman or any other mere possibility of a like nature cannot be transferred. B. A mere right of re-entry for breach of a condition subsequent cannot be transferred to anyone except the owner of the property affected thereby. C. An easement cannot be transferred apart from the dominant heritage. D. An interest in property restricted in its enjoyment to the owner personally cannot be transferred by him. D. A right to future maintenance in whatsoever manner arising, secured, or determined cannot be transferred. E. A mere right to sue cannot be transferred. F. A public office cannot be transferred, nor can the salary of a public officer, whether before or after it has become payable. G. Stipends allowed to military, naval, air force, and silver pensioners of government and political pensions cannot be transferred. H. No transfer can be made, 1. Insofar as it is opposed to the nature of the interest affected thereby, or 2. For an unlawful object or consideration within the means of Section 23 of the Indian Contract Act 1872, 9 of 1872, or 3. To a person legally disqualified to be transferred. E. I. Nothing in this section shall be deemed to authorize a tenant having an untransferable right of occupancy, the former of an estate in respect of which default has been made in paying revenue, or the lessee of an estate under the management of a court of wards, to assign his interest as such tenant, former, or lessor. 7. Person competent to transfer. Every person competent to transfer and entitled to transferable property or authorized to dispose of transferable property not his own is competent to transfer such property either wholly or in part, and either absolutely or conditionally, in the circumstances, to the extent, and in the manner allowed and prescribed by any law for the time being enforced. 8. Operation of transfer. Unless a different intention is expressed or necessarily implied, a transfer of property passes forthwith to the transferee all the interest which the transferor is then capable of passing in the property and in the legal incidents thereof. Such incidents include where the property is land, easements annexed thereto, the rents and profits thereof accruing after the transfer, and all things attached to the earth, and where the property is machinery attached to the earth, the movable property thereof, and where the property is a house, the easements annexed thereto, the rent thereof accruing after the transfer, and the locks, keys, bars, doors, windows, and all other things provided for permanent use therewith. And where the property is a debt or other actionable claim, the securities therefore, except where they are also for other debts or claims not transferable to the transferee, but not arrears of interest accrued before the transfer. And where the property is money and other property yielding income, the interest or income thereof accruing after the transfer takes effect. 9. Oral transfer. A transfer of property may be made without writing in every case in which a writing is not expressly required by law. 10. Condition restraining alienation. Where property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property, the condition or limitation is void, except in the case of a lease where the condition is for the benefit of the leaseor or those claiming under him, provided that property may be transferred to or for the benefit of a woman, not being a Hindu, Mohammedan, or Buddhist, so that she shall not have power during her marriage to transfer or charge the same or her beneficial interest therein. 11. Restriction repugnant to interest created. Where on a transfer of property an interest therein is created absolutely in favor of any person, but the terms of the transfer direct that such interest shall be applied or enjoyed by him in a particular manner, he shall be entitled to receive and dispose of such interest as if there were no such direction. Where any such direction has been made in respect of one piece of immovable property for the purpose of securing the beneficial enjoyment of another piece of such property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce such direction, or any remedy which he may have in respect of a breach thereof. 12. Condition making interest determinable on insolvency or attempted alienation. Where property is transferred subject to a condition or limitation making any interest therein reserved or given to or for the benefit of any person to cease on his becoming insolvent, or endeavoring to transfer or dispose of the same, such condition or limitation is void. Nothing in this section applies to a condition in a lease for the benefit of the leaseor or those claiming under him. 13. Transfer of benefit of unborn person. where on a transfer of property an interest therein is created for the benefit of a person not in existence at the date of the transfer, subject to a prior interest created by the same transfer. The interest created for the benefit of such persons shall not take effect unless it extends to the whole of the remaining interest of the transferor in the property. Illustration: a transfer property of which he is the owner to be in trust for A and his intended wife successively for their lives, and after the death of the survivor for the elderly son of the intended marriage for life, and after his death for A's second son, the interest so created for the benefit of the eldest son does not take effect because it does not extend to the whole of A's remaining interest in the property. 4. Rule against perpetuity. No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of such transfer, and a minority of some person who shall be in existence at the expiration of that period, and to whom, if he attains full age, the interest created is to belong. 15. Transfer to class, some of whom come under section 13 and 14. If on a transfer of property an interest therein is created for the benefit of a class of persons with regard to some of whom such interest fails by reason of any of the rules contained in section 13 and 14, such interest fails in regard to those persons only and not in regard to the whole class. 16. Transfer to take effect on failure of prior interest, where by reason of any of the rules contained in section 13 and 14 an interest created for the benefit of a person or of a class of persons fails in regard to such person or the whole of such class. Any interest created in the same transaction or intended to take effect after or upon failure of such prior interest also fails. 17. Direction for accumulation. 1. Where the terms of a transfer of property direct that the income arising from the property shall be accumulated where either wholly or in part during a period longer than A, the life of the transferor, or B, a period of 18 years from the date of the transfer. Such direction shall, save as hereinafter provided, be void to the extent to which the period during which the accumulation is directed exceeded the longer of the foresaid periods, and at the end of such last mentioned period the property and the income thereof shall be disposed of as if the period during which the accumulation has been directed to be made had elapsed. 2. This section shall not affect any direction for accumulation for the purpose of 1. The payment of the debts of the transferor or any other person taking any interest under the transfer, or 2. The provision of portions for children or remoter issue of the transferor or of any other person taking any interest under the transfer, or 3. The preservation or maintenance of the property transferred, and such direction may be made accordingly. 18. transfer in perpetuity for benefit of public. The restrictions in section 14, 16, and 17 shall not apply to the case of a transfer of property for the benefit of the public in the advancement of religion, knowledge, commerce, health, safety, or any other object beneficial to mankind. 19. Vested interest. Where, on a transfer of property, an interest therein is created in favor of a person without specifying the time when it is to take effect, or in terms specifying that it is to take effect forthwith or on the happening of an event which must happen. Such interest is vested unless the contrary intention appears from the terms of the transfer. A vested interest is not defeated by the death of the transferee before he obtains possession. Explanation: an intention that an interest shall not be vested is not to be inferred merely from a provision whereby the enjoyment thereof is postponed, or whereby a prior interest in the same property is given or reserved to some other person, or whereby income arising from the property is directed to be accumulated until the time of enjoyment arises, or from the provisions that if a particular event shall happen, the interest shall pass to another person. 20. When unborn person acquires vested interest on transfer for his benefit, where on a transfer of property, an interest therein is created for the benefit of a person not then living, he acquires upon his birth, unless a contrary intention appear from the terms of the transfer, a vested interest, although he may not be entitled to the enjoyment thereof immediately on his birth. 21. Contingent interest. Where, on a transfer of property, an interest therein is created in favor of a person to take effect only on the happening of a specified uncertain event, or if a specified uncertain event shall not happen, such person thereby acquires a contingent interest in the property. Such interest becomes a vested interest in the former case on the happening of the event in the latter, when the happening of the event becomes impossible. Exception. Where under a transfer of property, a person becomes entitled to an interest therein upon attaining a particular age, and the transferor also gives to him absolutely the income to arise from such interest before he reaches that age, or directs the income or so much thereof as may be necessary to be applied for his benefit. Such interest is not contingent. 22. Transfer to members of a class who obtain a particular age, where on a transfer of property an interest therein is created in favor of such members only of a class as shall attain a particular age. Such interest does not vest in any member of the class who has not attained that age. 23. Transfer contingent on happening of specified uncertain event, where on a transfer of property an interest therein is to accrue to a specified person if the specified uncertain event shall happen, and no time is mentioned for the occurrence of that event, the interest fails unless such event happens before or at the same time as the intermediate or precedent interest ceases to exist. 24. Transfer to such of certain persons as survive at some point or some period not specified. Transfer to such of certain persons as survive at some period not specified. Where on a transfer of property and interest therein is to be accrued to such a certain person as shall be surviving at some period, but the exact period is not specified, the interest shall go to such of them as shall be alive when the immediate and preceding interest ceases to exist, unless a contrary intention appears from the terms of the transfer. Illustration: A transfers property to B for life, and after his death to C and D, equally to be divided between them, or to the survivor of them. C dies during the life of B, D survives B. At B's death, the property passes to D. 25. Conditional transfer. An interest created on a transfer of property and dependent upon a condition fails if the fulfillment of the condition is impossible, or if forbidden by law, or is of such a nature that, if permitted, it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Illustrations: A lets a farm to B on condition that he shall walk 100 miles an hour in an hour. The lease is void. B, A gives R's 500 to B on condition that he shall marry A's daughter C. At the date of the transfer, C has died. The transfer is void. C, A transfers R's 500 to B on condition that she shall murder C. The transfer is void. D, A transfers R's 500 to his niece C. If she will desert her husband, the transfer is void. 26. Fulfillment of condition precedent. Where the terms of a transfer of property impose a condition to be fulfilled before a person can take an interest in the property, the condition shall be deemed to have been fulfilled if it has been substantially complied with. Illustrations: A transfers R's 5,000 to B on condition that he shall marry with the consent of C, D, and E. E dies. B marries with the consent of C and D. B is deemed to have fulfilled the condition. B, A transfers R's 5,000 to B on condition that he shall marry with the consent of C, D, and E. B marries without the consent of C, D, and E, but obtains their consent after the marriage. B has not fulfilled the condition. It is void. 27. Conditional transfer to one person coupled with transfer to another on failure of prior disposition. Where on a transfer of property and interest therein is created in favor of one person, and by the same transaction an ulterior disposition of the same interest is made in favor of another. If the prior disposition under the transfer shall fail, the ulterior disposition shall take effect upon the failure of the prior disposition, although the failure may not have occurred in the manner contemplated by the transferor, but where the intention of the parties to the transaction is that the ulterior disposition shall take effect only in the event of the prior disposition failing in a particular manner. The ulterior disposition shall not take effect unless the prior disposition fails in that manner. Illustrations. A transfers R500 to B on condition that he shall execute a certain lease within 3 months after A's death, and if he should neglect to do so, to C, B dies in A's lifetime, the disposition in favor of C takes effect. B, A transfers property to his wife, but in case she should die in his lifetime, transfers to B that which he had transferred to her. A and his wife perish together under circumstances which make it impossible to prove that she died before him. The disposition in favor of B does not take effect. Damn. 28. Ulterior transfer conditional on happening or not happening of specific event. On the transfer of property, and interest therein may be created to accrue to any person with the condition superadded that in case a specified uncertain event shall happen, such interest shall pass to another person, or that in case a specified uncertain event shall not happen, such interest shall pass to another person. In each case, the dispositions are subject to the rules contained in section 10, 12, 21, 22, 23, 24, 25, and 27. 29. Fulfillment of conditions subsequent. An ulterior disposition of the kind contemplated by the last preceding section cannot take effect unless the condition is strictly fulfilled. Illustration. A. Transfers R500 to B to be paid to him on his attaining his majority or marrying, with the proviso that if B dies a minor or marries without C's consent, or R500 shall go to D. B marries when only 17 years of age without C's consent. The transfer to D takes effect. 30. Prior disposition not affected by invalidity of ulterior disposition. If the ulterior disposition is not valid, the prior disposition is not affected by it. Illustration. A transfer of forms to B for her life, and if she does not desert her husband to C, B is entitled to the form during her life as if no condition had been inserted. 31. Condition that transfer shall cease to have effect in case specified uncertain event happening or does not happen, subject to the provisions of section 12 on a transfer of property, and interest therein may be created with the condition superadded that it shall cease to exist in case a specified uncertain event shall happen, or in case a specified uncertain event shall not happen. Illustrations. A transfers a form to B for his life, with the proviso that in case B cuts down a certain wood, the transfer shall cease to have any effect. B cuts down the wood, he loses his life interest in the form. B. A transfers a form to B, provided that if B shall not go to England within 3 years after the date of the transfer, his interest in the form shall cease. B does not go to England within the term prescribed, his interest in the form ceases. 32. Such condition must be invalid. In order that a condition that an interest shall cease to be exist may be invalid, it is necessary that the event to which it relates be one which could legally constitute the condition of a creation of an interest. 33. Transfer conditional on performance of act, no time being specified for performance, where on the transfer of property or interest therein is created subject to a condition that the person taking it shall perform a certain act, but no time is specified for the performance of the act. The condition is broken when he renders impossible permanently or for an indefinite period the performance of this act. The performance of the act. 34. Transfer conditional on performance of act, time being specified, where an act is to be performed by a person either as a condition to be fulfilled before an interest created on a transfer of property is enjoyed by him, or as a condition on the non-fulfillment of which the interest is to pass from him to another person, and a time is specified for the performance of the act. If such performance within a specified time is prevented by the fraud of a person who would be directly benefited by non-fulfillment of the condition, such further time shall as against him be allowed for performing the act as shall be requisite to make up for the delay caused by such fraud. But if no time is specified for the performance of the act, then if its performance is by the fraud of a person interested in the non-fulfillment of the condition rendered impossible or indefinitely postponed, the condition shall as against him be deemed to have been fulfilled. Election 35. Election when necessary. Where a person professes to transfer property which he has no right to transfer, and as part of the same transaction confers any benefit on the owner of the property, such owner must elect either to confirm such transfer or to dissent from it. And in the latter case, he shall relinquish the benefit so conferred, and the benefit so relinquished shall revert to the transferor or his representative as if it had not been disposed of. Subject, nevertheless, where the transfer is gratuitous and the transferor has, before the election, died, or otherwise become incapable of making a fresh transfer, and in all cases where the transfer is for consideration to the charge of making good to the disappointed transferee the amount or value of the property attempted to be transferred to him. Illustrations. The form of Sultan Pure is the property of C and worth Rs 800 A by an instrument of gift professes to transfer it to B, given by the same instrument Rs 1000 to C. C elects to retain the form. He forfeits the gift of Rs 1000. In the same case, A dies before the election. His representative must out of Rs 1000 pay Rs 800 to B. The rule in the first paragraph of this section applies whether the transferor does or does not believe that which he possesses to transfer to be his own. A person taking no benefit directly under a transaction but deriving a benefit under it indirectly need not elect. A person who is in his one capacity takes a benefit under the transaction may in another dissent therefrom. Exception to the last preceding four rules, where a particular benefit is expressed to be conferred on the owner of the property which the transferor possesses to transfer, and such benefit is expressed to be in lieu of that property. If such owner claim the property, he must relinquish the particular benefit, but he is not bound to relinquish any other benefit conferred upon him by the same transaction. Acceptance of the benefit by the person on whom it is conferred constitutes an election by him to confirm the transfer. If he is aware of his duty to elect and of those circumstances which would influence the judgment of a reasonable man in making an election, or if he waives inquiry into the circumstances, such knowledge or waiver shall, in the absence of evidence to the contrary, be presumed. Such knowledge or waiver shall, in the absence of evidence to the contrary, be presumed if the person on whom the benefit has been conferred has enjoyed it for 2 years within doing any act to express dissent. Such knowledge of waiver may be inferred from any act of his which renders it impossible to place the persons interested in the property possessed to be transferred in the same condition as if such act had not been done. Such knowledge of waiver may be inferred from any act of his which renders it impossible to place the persons interested in the property professed to be transferred in the same condition as if such act had not been done. Illustration: A transfers to B an estate to which C is entitled, and as part of the same transaction gives C a coal mine. C takes possession of the mine and exhausts it. He has thereby confirmed the transfer of the estate to B. If he does not within 1 year after the date of the transfer signify to the transferor or his representatives his intention to confirm or to dissent from the transferor or his representative may, upon the expiration of that period, require him to make his election, and if he does not comply with such requisition within a reasonable time after he has received it, he shall be deemed to have elected to confirm the transfer. In case of disability, the election shall be postponed until the disability ceases or until the election is made by some competent authority. Appointment. 36. Appointment of periodical payments, determination of interest of person entitled. In the absence of a contract or local usage to the contrary, all rents, annuities, pensions, dividends, and other periodical payments in the nature of income shall, upon the transfer of the interest of the person entitled to receive such payments, be deemed as between the transferor and the transferee to accrue due from day to day, and to be apportionable accordingly, but to be payable on the days appointed for the payment thereof. 37. I said appointment. It might be apportionment. Yeah, appointment. Apportionment of benefit of obligation on severance. When, in consequence of a transfer, property is divided and held in several shares, and thereupon the benefit of any obligation relating to the property as a whole passes from one to several owners of the property, the corresponding duty shall, in the absence of a contract to the contrary amongst the owners, be performed in favor of each of such owners in proportion to the value of his share in the property, provided that the duty can be severed, and that the severance does not substantially increase the burden of the obligation. But if the duty cannot be severed, or if the severance would substantially increase the burden of the obligation, the duty shall be performed for the benefit of such one of the several owners as they shall jointly designate for that purpose, provided that no person on whom the burden of the obligation lies shall be answerable for failure to discharge it in manner provided by this section, unless and until he has had reasonable notice of the severance. Nothing in this section applies to leases for agricultural purposes unless and until the state government by notification in the official gazette be direct. Official gazette so directs. Illustrations. A sells to B, C, and D a house situated in a village and leased to E at an annual rent of Rs. 30 and delivery of one fat sheep. B having provided half the purchase money, and C and D 1/4 each, E having notice of this must pay Rs. 15 to B, Rs. 7.5 to C, and Rs. 7.5 to D, and must deliver the sheep according to the joint direction of B, C, and D. B, in the same case, each house in the village being bound to provide 10 days' labor each year on a dike to prevent inundation. To prevent inundation, E had agreed as a term of his lease to perform this work for A, B, C, and D severely require E to perform the 10 days work due on account of the house of each. E is not bound to do more than 10 days work in all, according to such directions as B, C, and D may join in giving. Whenever we come back, we're going to get on B, transfer of immovable property. Whenever we get back, transfer of immovable property.